At the conclusion of this lecture, you will understand the structure and operation of the criminal courts and be able to distinguish between the civil and criminal law process. A crime is an offense against society's accepted behaviors and is prohibited by law. This prohibition is necessary in order to protect society as a whole. Examples of crimes against the state are theft, robbery, murder, or manslaughter. The main aim of criminal law is to punish offenders, but also to deter others from doing the same, as they know the consequences of potential crimes. A criminal action is brought by the Crown Prosecution Service on behalf of the state. This is usually brought following a police investigation and arrest. The accused is entitled to free legal aid in order to assist his or her defense where they are from a low-income background. This is done to ensure fairness in the criminal system. Either party in a criminal case may appeal to a higher court against the decision. Criminal cases are reported in the form of Regina v. Regina is simply Latin for queen, and case references are usually abbreviated to or v. The burden in proving and bringing a case rests on the Crown, and this is not an easy task. Beyond reasonable doubt means that the jury must have no reasonable doubt in their mind that the defendant is guilty of the crime he is being tried for. The defendant will be tried by magistrates in the magistrates' court for non-serious crimes, or by a judge and jury in the Crown Court for serious crimes. In distinguishing between criminal and civil actions, it has to be remembered that the same event may give rise to both. For example, where the driver of a car injures someone through their reckless driving, they will be liable to be prosecuted under the road traffic legislation. But at the same time, they will also be responsible to the injured party in the civil law relating to the tort of negligence. Availing of one of these options does not prevent you from using the other. If there is no loss suffered by a person, then there cannot be a civil proceedings. Under criminal law, there does not have to be a person who has suffered loss, for example, a parking fine or a speeding offence. The division between civil and criminal law is seen most clearly in the Court of Appeal, which has two divisions. The Court of Appeal, Civil Division, headed by the Master of the Rolls, and the Court of Appeal, Criminal Division, headed by the Lord Chief Justice. We will now turn towards examining the structure of the criminal court. Given the vast number of criminal cases being brought from the English courts to the European Convention of Human Rights, it can be argued that this is the highest court to hear criminal matters in England. The European Convention of Human Rights hears matters on alleged human right violations that fall within the ECHR. Claimants are required to exhaust domestic rights of appeal before a case can proceed to the European Convention of Human Rights. United Kingdom courts must take into account European Convention of Human Rights rulings when applying the European Convention of Human Rights, and convention rights found in the Human Rights Act. The Supreme Court is the final court of appeal for all criminal cases arising in England, Wales, and Northern Ireland, but not Scotland. The Court of Appeal's Criminal Division hears appeals from the Crown Courts. Decisions may be taken by a single judge. If a single judge dismisses your appeal, the matter can be referred to the Criminal Cases Review Commission, who can then refer the case back to the Court of Appeal for a full hearing. The Crown Court hears matters relating to serious offences, known as indictable offences, for example, murder. Additionally, it hears appeals from the magistrates' courts, arising from England and Wales and Northern Ireland. The defendant is tried by a judge and a jury in the Crown Court. For less serious offences, known as summary offences, the defendant is tried by magistrates, and for either way offences, i.e., an offence that can be indictable or summary in nature, the defendant is usually tried by magistrates. The defendant and magistrates can elect for a jury trial. Criminal appeals from the magistrates go to the Crown Court or to the Queen's Bench Divisional Court, by way of case stated, on a point of law or on the basis that the magistrates went beyond their proper power. The following is a useful diagram on the criminal and civil court structure of the English legal system. In conclusion, the criminal process falls within public law. The government is involved in prosecuting criminal matters. The standard of proof required is beyond reasonable doubt. Thus, it is of a higher standard than required by civil law.